Hello, my name is Daro Weilburg, and I am a Jehovah's Witness in good standing. Or if you prefer, I'm one of Jehovah's Witnesses in good standing. Now, many of the apostates will disagree with that. And they say, oh, no, he's not a Jehovah's Witness in good standing. Prove it. I don't have to prove it, I'm saying it. Addressing, first of all, this video is not approved by the Watchtower Bible and Tract Society of New York. It's not approved by the Watchtower Bible and Tract Society of Pennsylvania. It's not approved by those 9 faithful, loving, considerate men who take the lead among the Jehovah's Witnesses, located there in Warwick, New York. And it's not approved by any local body of elders. See, I don't work for the elders, I don't work for the governing body, and I don't work for the Watchtower Bible and Tract Society. I work for Jesus Christ. All 8.6 million Jehovah's Witnesses work for Jesus Christ, period. The governing body, those 9 faithful, loving members of the governing body, are not our leaders. I wish people would get over that. And neither is the Watchtower. The Watchtower Bible and Tract Society is merely a legal entity that is required by the government to collect funds by donations and keeping records of all that stuff for the government. The first thing I'm going to do here today, and this is a side point, is by addressing the ex-JWs claiming that they left Jehovah's Witnesses. Now you'll see on YouTube, if you research, you'll see a lot of these people, I left Jehovah's Witnesses, I was with Jehovah's Witnesses for 40 years and I stopped. Every single person who says they left the Jehovah's Witnesses is a barefaced liar. And I got the proof. What's the proof? Well, when each of those people were baptized, each one, fully cognizant of what they were doing, were asked 2 questions. Now, perhaps in front of thousands of individuals. The first question they were asked, on the basis of the sacrifice of Jesus Christ, have you repented of your sins and dedicated yourself to Jehovah to do his will? Dedicated yourself to Jehovah. Your answer, please. And with a loud, resounding voice, they all said, I do. Now, the second question they were asked is, do you understand that your dedication and baptism identify you as one of Jehovah's Witnesses in association with Jehovah's organization? They violated their vows. Both these questions they answered perhaps in front of thousands of people. They answered, I do. And then they violated their vows. They're liars that some of them made before perhaps thousands of people, and they're liars. See, I left Jehovah's Witnesses. That makes your vow a lie. That makes you a barefaced liar. Sorry, that's just it. See, their claims make them liars and oath breakers. They are just like those who commit adultery. You made a solemn vow to your spouse, to their spouses. They did. And then they violated those vows. They're just barefaced liars. They did not keep their vows. Sadly for them, every single one who claims they left Jehovah are admitted liars. And on most occasions, actually, Jehovah booted them out of his organization, and their egos forced them to claim they left on their own, so they save face. No one wants to admit they were expelled. Now these liars beat their brothers. Now I want to address why I claim I'm persecuted by all these state government officials. Now, Richard Castellane, this idiot I worked for, sent me these 2 emails. We're going to hold this up in front of the camera here, and hopefully you can see it. Those are the 2 emails on 1st and 2nd of February, 2022. Those are the emails. You've been operating without my permission at Jehovah's Witness cult camp. How many calls on a daily basis have you made from my premises extolling Jehovah's Witnesses? Okay. This is why all of this came down. This is why right here. This is why. So all you naysayers out there that say I wasn't persecuted, that's why. Castellane sent me those 2 emails in February. Every single state actor from the original Judge Daniel Vinyl of Stockbridge Township, Town Court, to Judge Patrick O'Sullivan knew this entire case began with these 2 emails. They all knew I was persecuted by Ethan C. Coase, the cop, the New York cop, the trooper, or whatever they call state cops. It's on his body cam. Diane Button admitted Robert Altman had my internet disconnected because he didn't like the videos I posted on this YouTube channel right here. Norman Button told the cop that I removed the plywood ramp so I could get out. And yet they arrested me for removing that plywood ramp later because they reattached it. Later they arrested me for it, put me in jail. Now that's in the body cam footage shot on March 12th. That same plywood ramp was leaning against a tree when the 3 state troopers arrested me on May 10th, 2022. It was leaning against a tree when they passed by with me in handcuffs. In fact, that ramp was never reattached and eventually disappeared. Yet they put me in jail when I removed it. It is all on the body cam that the very cop shot. Now, when one looks at the body cam footage of both events on March 12th and May 10th, one would have to be a complete buffoon to conclude that any crime was committed, except on the part of Richard Castellane and his cohorts, his goons. And when Castellane flooded my basement apartment with septic tank water in an effort to evict us back in January of 2022, he committed a crime. When Castellane cheated me out of the use of the internet and when he blocked the entrance exit to my apartment, he committed a crime. Yet, the cops refused to investigate. A landlord cannot disconnect services or block entrance to an apartment under any circumstances. Only a judge in a court of law can evict someone. Landlord can't evict you. And that's, I believe, in all 50 states. I don't know. I can't say that for a fact, but I believe it is the same in all 50 states. Now, on June 18, 2023, Castellane passed away. The New York State's Attorney's Office of Madison County knew Castellane passed away. After all, Castellane was their star witness and only witness against me. Yet that ADA, John S. Rogers is his name, is a punk. He didn't even show up for the next couple of hearings because he knew Castellane had died. And he didn't want to have to admit it in court, and thereby causing the court to dismiss the case. Now, during the July 19, 2023 hearing, ADA Rogers wasn't there. The judge was told that the mental examination had taken place. It never took place. I had proof it never took place. In fact, most of you have already seen the video that it never took place, which was recorded on July 14th. That was the date of the examination. Now, the judge then said he would accept a motion to proceed on my own behalf during the next hearing. Now, isn't it ironic that these idiots, and this judge is an idiot too, that Mizrazic, whatever his name is, he's an idiot, trying to stick up for that idiot, Brenden Rigby. Up and into that date of July 14th or July 19th. Actually, if we go back to August or April 25th, when I received the court order, and everybody else received it too, because that's when they made it. Anyways, when you look back at that, it's a 7:30 order. Rigby claims that the judge issued this order on March 1st, 2023. And here's a copy of that email. Okay. Now, what it says there, basically, you can stop and pause. Here's a copy of the signed order. You were present in court when the judge orally ordered the 7/30/30 examination. Now, prior to this time, in the other emails, he never said that when I accused him of the judge ignoring him. He never said, you were there in court. No, he only said that after April 25th because he had manufactured the court order. Now, he didn't do it himself, of course, but he was complicit in it. And now, when we're in there in the hearing or in the examination room, you'll notice on that video that we were at a mental health clinic. Now, here's what Brenden Rigby says. I told him, first of all, he told me, he says, well, you violated HIPAA rights. First of all, folks, public cannot violate HIPAA. What? Yeah. I can't, you can't, unless you're a personnel of a medical facility, you cannot violate HIPAA. HIPAA is their requirements on them. But you see, this moron attorney who thinks he knows the law and doesn't, he writes me this. I agree that people enjoy no reasonable expectation of privacy while in a public place. You, however, were in a mental health counseling waiting room. A public place. You idiot. Access by going through a metal detector manned by law enforcement. As if that has anything to do with HIPAA. They're there to keep the violence down, you idiot. A setting where people receive confidential health care. They don't receive confidential health care in the public waiting room, you moron. You know, this guy is a complete moron. I don't see how this guy ever became an attorney. Patient identities are considered PHI, prohibited healthcare information, protected by HIPAA. Again, not in a waiting room. Not in a public waiting room, Mr. Brenden Rigby. You articulated a broad interpretation of HIPAA in portion of the exam that you deleted from the video you uploaded. And that's a lie. I told those doctors when I left that exam that if they talk to Brenden Rigby, they are violating my HIPAA rights. I told them that. And you know what? They did. This guy's an attorney, folks, and he doesn't know the HIPAA requirements. Here he says again, this is June 23rd. He says, there is no newly written court order because the law does not require one. You are ordered to be examined pursuant to CPL 73030. You were present in court when the judge reiterated that you need to attend the examination. The judge never reiterated anything. That's a lie. And he never issued the order. Never. So, yeah, that ADA Rogers, he's also a punk. He knew all this. You know, the worst part about it is they all knew I was innocent. Yeah, they all knew I was innocent. And now, during this July 19th hearing, where the judge was told that the mental examination had taken place, it had not taken place. And I had proof it didn't take place. The judge then said on the next hearing, which was August 23rd, that he would accept a motion on my behalf to proceed in pro se on my own behalf to proceed. Now here this idiot moron, Brenden Rigby, tells the court that I could be mentally incapacitated, and yet here the court is telling me I can represent myself. So the court did not believe I was mentally incapacitated, and neither did Rigby, because he also told me that. Yeah. Yeah, Rigby actually told me that I could represent myself. He even told me that in the hearing there. Yeah. Now, here I wrote Rigby, oh, what a practice, oh, what a tangled web we weave once we practice to deceive. Here it is. And then he writes back, since you quoted Shakespeare, here's a copy of that. He says, since you quoted Shakespeare, here's another apt quote. Plurality should not be posited without necessity. The simplest explanation is usually the best one. That's a misnomer. That is not true. But oh, where the tangled web we weave, once we practice to deceive, did not come from Shakespeare. It came from Sir Walter Scott, who wrote the play Marmion. But you see, Mr. Rigby's a complete idiot. Now, ironically, the same judge who allegedly signed this order claiming that I could be mentally incapacitated and not able to assist in my own defense, that same judge opined that I could be incapacitated. That was wrong. The examination that never happened is on YouTube. You can get it. It's down below. You can get it. The charlatans posed as doctors were Dr. George D. Annis and Dr. Kumar Taran. Now, these two clowns refused to examine me and dismissed me on July 14th. You can see the video link. And now that you have watched that video, where that clown Annis tells me to leave the examination, look at that report that this punk puts into the court. Now, this is his report. I'll hold it up again. I hope you get the gist of it. That's the first page. You can see here the court received it and the date. See here his letterhead up here. Okay. And then we've got this. Okay. There it is, the complete report that he filed to the court. So basically, if you call George Annis a punk, you have a mental disease. And you know, the word punk that I use represents the smart aleck bully. That's what it is. But that was the basis for his report. It's there in the video, folks. Now, the other doctor knew better. He didn't libel me and published the libelous report to the court. Dr. George D. Annis demanded that Rigby attend the examination. He kept trying to convince me. And when I refused Rigby's presence, he refused my wife to be present. At that very moment, I could see that it was a setup, and they didn't want any witnesses. Rigby had already conspired with Annis to find me mentally incapacitated, so the court would dismiss this case. Remember, they wanted to dismiss this case. They all said that it was a premier plea agreement. I should take the plea agreement. I wouldn't take it because I didn't do anything wrong. When I informed Rigby that Castellane had died, he then moved the court to dismiss on August 23rd, 2023, and they were elated. I was not in attendance, yet the court dismissed the case. And that was on August 23rd, 2023. So I'm surprised the judge didn't issue a bench warrant. But they didn't want no part of that. Now, court records are public records. So this charlatan, unless, of course, they're sealed by the court, like, for instance, juveniles involved or women, rape cases, stuff like that. Sometimes the records are sealed. Now, this charlatan, Dr. George D. Annis, being a punk that he is, and he proved it, and again, the word punk means bully or smart aleck, he certainly did not include his diagnosis from any examination. The video bears that out. Instead, Dr. George D. Annis, the clown, decided he would use just my emails and replies to Rigby's emails, disregarding the emails and the reply emails I sent. It was rigged. As I pointed out earlier, there were only 3 routes DeSantis, that $205,000 wannabe attorney, ADA John S. Rogers, Brenden Rigby, and these judges. The kangaroo courts in Oneida with that lying court clerk, Carla Fitzgerald, wanted. They wanted that either I die, Castleton dies, or this clown Annis, posing as a doctor, finds me incapacitated to assist in my own defense. Now, the court could not act upon this because there has to be two doctors. So the court couldn't have acted upon that sole report. And, of course, the other doctor was smart enough not to libel me. Now, it's difficult to get every detail, but I believe there's enough evidence here to prove they violated federal criminal laws. That would be Carla Fitzgerald, by committing a fraud on the court, and, of course, constitutional laws and HIPAA laws. They forged that court order, and then these two doctors conspired with Brenden Rigby to find me incapacitated. At least one doctor did. Every single bureaucrat since that time has entertained this case as part of the persecution by Richard Castleton, as accessories to that persecution. Most of the other county employees tried to cover it up. Therefore, they're guilty of the prejudice against my religious beliefs, my freedom to speech, and my freedom of the press. Now, in the video you saw and heard Rigby telling me that my exercising my constitutional rights had consequences. This is what he said. It's in the video. They have consequences. My rights to freedom of speech, freedom of religion, and freedom of the press were severely violated by my own court-appointed attorney right here. He violated them because he went and asked the court for a CPL 730.30 examination, mental examination, because I refused to cop to a plea and I wouldn't talk to him. The question now is, will my right to have a fair and impartial hearing before the Madison County Supreme Court Judge Patrick O'Sullivan occur? Now remember, Patrick O'Sullivan forced me to serve each one of the 5 respondents individually. Well, you know what? When the process server went to serve them, one guy accepted for everybody. One guy. Now, why couldn't Judge Patrick O'Sullivan tell me, you know what, serve the county? It'll be good, Mr. Weilburg. But no, see? So right away, quick, he's against me. And then this Patrick Sullivan wants to blame me for what his clerk did. The clerk sent this premature letter because not all the paperwork was filed yet. Now, if the Oneida City Court judge ever says that he issued that March 1st, 2023 court order, he's a liar. And I'll tell him that right to his face. That fancy law firm, Hancock and Estabrook, represents the Madison County 4. Elizabeth, a.k.a. Betty Spaulding, Catherine Hopkins, John M. Becker, and Jeffrey Iamel. He's an attorney himself. The New York Attorney General's office represents that lying Oneida City court clerk who committed a fraud against the Oneida City Court and served a forged document by email on August 25th to the Madison County Mental Health Department. Then thereafter, the Madison 4 tried to cover over the fraud upon the court. Yeah, each and every one of them people tried to cover it over. The one guy tells me I appeal the denial and the FOIL request, and he tells me, oh, you have to go through HIPAA, through the HIPAA request. You're releasing court documents. You got to do that. So I did that, and they still refused. Now, instead of allowing me to serve process on the 2 attorneys representing these 5 respondents, again, Judge Sullivan cost me $375. Now, when the process served, he only served the one individual, who was Michael Cavell, who was the clerk of the Madison County Court. Now, why didn't this judge just let me serve 1 copy to this Michael Cavell? Because he's prejudiced against me. And like I said, Judge Sullivan tried to blame me for the court's mistake of prematurely sending an appearance notice on my petition for writ of mandamus. Mandamus is a court pleading where anyone can ask the court to order the government to do their job. And we're dealing here with a single email, folks. One single email that isn't even that big. That's not the email, but it's just one single email. That alleged March 1st, 2023 email does not exist. And it does not provide McDonald's secret sauce ingredients, nor does it disclose any top secret covert government operation. It is merely a notification of an order from the court which was attached to it. regarding me, Mr. Daro Weilburg. Now, perhaps with the case number and details of the order. Nothing top secret, and it is a public record. Public record. I don't care what this court says. This judge knows that it's a public record. They all knew it. Now, when I tried to obtain this email from Carla Fitzgerald, all I got was lies. Yeah, here. She gives me this. Look at this, folks. This is what she gives me and tells me it's an email. You see that, folks? That's what she gave me. And she tells me, oh, yeah, that's an email. She gave me that in person. Here's the email, Mr. Weilburg. That's not an email. That's printed from her desk. That's not an email. This would be an email, something like this. That would be an email, a copy of an email. So when I tried to obtain a copy of that email, that March 1st mysterious email, under the Freedom of Information law on Madison County Mental Health Department, they denied my request. So I appealed to the Madison County Board of Supervisors, the chairman, John M. Becker. He told me I would have to produce identification to obtain the record, which was part of a medical record, and HIPAA laws apply. So I did that. And then this employee, Catherine Hopkins, lies her fanny off and claimed I was never seen there. And you got the video, folks. This is the runaround that these government officials are giving me. And this judge is letting it happen. He knows this because it's all in my report with the emails and everything that they sent, with the proof, evidence of what these people said to me. Now I have my appearance there on the video. Then I finally get this letter from this clown, Jeffrey Ayumel, that the email is protected under the disclosure laws pertaining to documents. That's a barefaced lie. I asked Carla Fitzgerald under the Freedom of Information Act or law for the March 1st, 2023 mysterious email. She says her organization or her office is not under the Freedom of Information law. So I asked for it under the production of documents in the criminal case. She merely responded that she gave me the email. She gave me the email. That is not an email, folks. Where's the email? Now, my 1983, let's go into that now. My 1983 U.S. District Court action against Ethan C. Coast, the state cop who illegally arrested me, not once but twice, is awaiting a ruling on the state's motion to dismiss. It's been over 5 months. My writ for mandamus is pending in the Madison County Supreme Court. Now, I keep looking here because I'm trying to get a copy of the alleged mysterious March 1st, 2023 email sent from the clerk of the Oneida City Court to the Madison County Mental Health Department, and a copy of that non-existent March 1st, 2023 email, which was allegedly received by the Madison County. So I want both of them. I want the court to send me the copy of the email they sent to the Madison, and I want Madison County to give me a copy of the email they received. Both, 2 copies. Now, both cases are pending in the courts. So here's the point. I probably won't receive justice in Patrick O'Sullivan's court. He's already against me. He's already ruled against me and thinks he could have sided with me. If he had actually read the report and would see that these people are giving me a runaround on a stupid, stinking email. One email. Okay? And I know this judge knows all of this. He knows all of this. All these people know all of this. They know everything that has transpired in this case. If they don't, it's their own fault. Because it's all a matter of public record, folks. It's all a matter of public record. Now, on another occasion, this is cute here. This is from Brenden Rigby now, okay? And I just wanted to cover this, and then I'll let you folks go here because I know it's getting long. But he says, "Thank you for the photos. Can you please send me the versions that do not have text arrows on them?" What a moron. They have text arrows to show what happened. And now he goes this. An ex parte order doesn't mean there was a hearing ex parte. He says it right there. I've got it right there. You see that, folks? That's what he says. When an order of protection is marked ex parte, that generally means that the defendant was not present when it was issued. Duh. This guy's a moron. It's not that rare or special for a request to be made by the DA's office. That would mean that they had some type of hearing or communication ex parte. Now, and here he says this. After I give him all the affidavits and the eyewitnesses, he says this, which is, our investigator is allowed to reach out to the witnesses. I'm not sure what you mean when you say you would be charged with witness tampering. He wanted me to contact these witnesses. Well, now, if I contact the witnesses, I'm the defendant in a criminal case. That could be tampering with the witnesses. You see how stupid this guy is? Now, this guy calls himself an attorney. I'm the criminal defendant. And I'm going to go contact witnesses on my own behalf? So here, Judge Patrick O'Sullivan, here's your good attorney. Next time you tell somebody in court that an attorney is good, you should make sure that he is really good instead of just your opinion after having seen him and not seen the truth about what he stands for. You see him in an open courtroom. That's all. Yeah, he's a good attorney. Brenden Rigby's good for nothing. He's a lying punk, just like every single one of these officials. They all covered this thing up. You be the judge. Let me know in the comments what you think. And thanks again for watching this video.